So let's look at a case from the Eastern District of Missouri. This has to do with Experian reporting a Chapter 7 discharged debt, but actually reporting it as if it was still owed. And the consumer sued under the FCRA, specifically Section 1681EB, which is the section that says you have to use reasonable procedures to assure maximum possible accuracy. And Experian wanted the case thrown out. The court denies it. So I want you to see this because it gives us some more insight into what the bureaus are doing with discharged debt when they refuse to follow the law. And you'll also see kind of how the FCRA works here. All right, so here's a quick background. Files Chapter 7, July 15. Discharged October 9th. Pretty typical, 3 or 4 months you're discharged. And then December, so that's about 2 months later, pulls credit report. So I've written that down here just to kind of keep us all straight on factually what happened. There's a Missouri payday loan that was being reported as past due. Now, the other bureaus, Equifax and Trans Union, reported this debt as discharged. All right, so what do we have going on here? This was listed in Schedule F. That's where we put our unsecured claims. And so Experian should have known to report that Missouri payday loan as discharged or otherwise show a zero balance. And when we say discharge, it would say discharged in bankruptcy or included in bankruptcy. So 2 other dominant credit reporting agencies, Equifax and Trans Union, did not report the account. So a variety of damages, emotional distress, mental pain, denied credit. So there's suit. Now, this is correct the way it's worded. It's just maybe a little different than we normally say it. Single claim under 15 U.S.C. Section 1681N. That's when you have a willful violation. Really, the way we would say it is brought a claim under 1681EB for willfulness and negligence. And so this just the judges worded it slightly different here. So willful or negligent violation, 1681EB. The critical thing to remember with EB is that is normally when you do not do a dispute. Now, if we do a dispute, it doesn't get fixed. We would bring an I claim as well as an EB claim. But normally when you just see an EB claim, that means no dispute has been done. So Experian says, hey, you need to throw this lawsuit out. This is what's called a motion to dismiss. Well, why? Well, because plaintiff has not pled sufficient facts to plausibly, remember this from other videos, the test is, have you put forth facts that you're alleging, and those facts make it plausible that the plaintiff, the consumer, will win. So they say, no facts to plausibly infer Experian failed to follow reasonable procedures as required by 1681EB. Further contends EB requires a plaintiff to alert the credit bureau of the discrepancy to give them time to investigate. Now, they absolutely know that is 100% false, but they do it anyway because their thought is, hey, a judge might fall for it. The other side might fall for it. And this is a totally different section. We have to do a dispute under Section I. Remember, I is for investigation. But EB does not require notice that, hey, there's a problem. It's just the fact that you, the credit bureau, failed to have reasonable procedures to assure maximum possible accuracy, and you have something that's false on here. So the plaintiff, the consumer, opposes this, says, hey, I allege this properly. And there was this settlement called White versus Experian. This all the way back in 2005 from California. And this is where Experian agreed to, as this is termed up here, agreed to a set of reasonable procedures for dealing with Chapter 7 bankruptcies. Now, I'll point this out. What was reasonable back in 2005 may not still be reasonable in 2022. There's a whole lot that's changed in 17 years. But it at least gives you kind of the minimum that Experian should be doing. And then the plaintiff also says, I reject this idea that we have to give you notice before bringing an EB claim, which are absolutely right on that. So this is just the standard here. State a claim to relief that is plausible on its face, not bound to accept as true legal conclusions. So anyway, willful is 1681N, 1681O is negligent, and then EB is at maximum possible accuracy. So here's EB. When you prepare a consumer report, so this means It's not enough for me just to pull my credit report and see an error. Some other user of some form or fashion has to see the credit report or pull the credit report. So another way to say it is the credit bureau must publish the credit report to somebody. So it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. So if a credit bureau creates a credit report, and when we use this term credit report or consumer report, we're talking about something that somebody else uses, not what we pull ourselves. So to state a claim, the court here describes two elements. I've added a third. Number one, the report was inaccurate in some way, and the inaccuracy was due to failure to follow reasonable procedure. Now, the third is it has to be publication. Okay. Experian only challenges sufficiency of the second element. So they don't argue in this motion to dismiss. Now, they could argue it later, but they don't argue that, the credit reporting was accurate. They're saying, all right, let's assume it was inaccurate, but we followed reasonable procedures here. So the reasonableness of the procedures and whether the agency followed them will be jury questions in the overwhelming majority of cases. Nevertheless, the act does not render the credit bureau strictly liable for inaccuracy. Strictly liable means if there's something that goes wrong, you're absolutely on the hook for it. So in law school, we learned about when the circus comes to town and they let the lions loose, they're strictly liable for what happens. The FDCPA, in a lot of respects, is a strict liability statute. Here, the FCRA is not a strict liability statute, so the mere fact that there's something wrong does not automatically mean the credit bureau is liable. That's a pretty good indication, but it does not automatically mean that. So there must be a showing that the inaccuracy resulted from the agency's failure to follow reasonable procedures. So you've got to show that, again, in the motion to dismiss, there's been no discovery, no depositions, nobody swearing under oath. So we're just looking at the complaint. What does the complaint say? And is it plausible that the plaintiff, the consumer, can be successful here? So 1681EB does not hold a reporting agency responsible where an item of information received from a source it reasonably believes is reputable that turns out to be inaccurate unless the agency receives notice of systemic problems. So let's sort of restate that. If a credit bureau gets information from a source that it reasonably believes to be legitimate, reputable, trustworthy, then the fact that one piece of information turns out to be wrong won't be enough to just automatically show the credit bureau is at fault unless they had notice of it. However, this notice may be constructive. Section EB does not require a consumer to notify the credit bureau of the error. So here are some examples. A case from Minnesota. Provision of the FCRA at issue, 1681EB, does not require a consumer to report inaccurate information to an agency before filing a lawsuit. For example, courts have held CRAs, those are the credit bureaus, must look beyond information furnished when it's inconsistent with its own records, contains a facial inaccuracy, or comes from an unreliable source. This is from the 10th Circuit back in 2015. So if the credit bureau gets information and their own documentation shows this is contradictory or it looks suspect here, or there's just an obvious error on there, well, that's going to be enough to trigger an obligation to do something. Okay, so I'll give you an example. I had a person that they were born in like 1985. And they had an account, so they were the individual owner for it, that was opened in 1973. That's impossible, okay? Now, I mean, you could sort of argue, well, maybe their parent owned it, made them a joint user, then the parent died. But, I mean, just on its face, it sort of screams out at you like, this doesn't look right. Or I've had cases where one account will report my client as dead, but all the other accounts show activity going on. Well, the credit bureau, you go, it's kind of funny. Something doesn't look right here. Let's investigate this. All right, so let's go back to the text. For example, let's see here. Experian may well be correct that the inaccuracy here, reporting that discharged debt as past due, was an isolated incident rather than the result of unreasonable procedures. But that question is better suited for resolution at a later stage on a more complete record. In other words, let's get people swearing under oath. Let's get documents. Let's see what really happened. At this early stage, the court is persuaded by multiple district court determinations that notice of a Chapter 7 bankruptcy, and here's the evidence of it, Experian reports the bankruptcy. So if they report the bankruptcy, they can hardly say, we didn't know you'd filed bankruptcy. Makes it plausible to allege that continued reporting of a prior unsecured debt is unreasonable. So again, let's stop for a second. What we're talking about here is if I filed bankruptcy on January 1st of 2020, then anything that existed that's an unsecured debt, we're not talking about a car loan or a home loan. Let's just deal with like credit cards, medical bills, signature loans, things like that. Anything before January 1 of 2020, the credit bureau should presume that that debt has been discharged once I get a discharge from my Chapter 7. So that's what we mean by pre-petition debt. We're talking about, or this says a prior debt. You'll also see it referred in cases as pre-petition, before the petition for bankruptcy. So the prior debt prior to the bankruptcy being filed. So here's a case. Plausibly alleged CRA acted unreasonably, had reason to know the reporting his Citibank account was inaccurate because it was also reporting his bankruptcy as discharged and all other bankruptcy debts as discharged. And that's kind of the odd thing. A lot of times they will report, let's say I have 10 accounts on my credit report that were discharged. They'll report 9 of them as discharged, but not the 10th one. And again, that ought to trigger some red flags, right? Where you go, hey, what's going on here? You know, it's kind of like when you're I don't know, trying to do a reservation in a hotel and you put a date that's a week in the past. You know, so like today I'm recording this, what is it? I think it's the 6th of December. If I try to schedule a hotel, instead of putting in the 7th, I put in November 15th. It sort of goes, error. You must select a date in the future, right? So that's how the credit bureau should be. All right, so here's something else. Oh, and this footnote's just saying when you do notify the credit bureaus, that's under Section 1681I. So here's another example. Plausible claim it's not reasonable CRA to follow procedures that assume debts related chapters are not discharged unless they get information they were. So the credit bureaus would like to say, well, we have to be notified that those debts were discharged and included. And what the court's saying is if you know about the bankruptcy, then any debts before that, you should assume that they are discharged. And to assume they're not discharged is unreasonable. Here's a recent case. The White settlement makes clear that CRAs knew that unsecured consumer debts are typically discharged Chapter 7 proceedings. And notice that not updating such accounts after Chapter 7 may fail to comport with 1681 EB. So this is out of Minnesota. I think I may have this case pulled to do a video on this one. So the White settlement's not binding on this court. Now, I will say this. A lot of judges wrestle with this issue. Are we bound by the White case? Because Experian wants to come in and say, hey, all we have to do is what the White settlement says. But the problem with that is things change over 17 years. Technology changes. The way businesses handle has changed. And so I may do a video on that just to show how that's happened here. So they say it's not binding, but it lends plausibility that they were on notice of a systemic problem. And then the White settlement has all these sort of complicated rules about, well, during this time you check or you quote scrub to find out if an account was included. We won't get into all that detail. Experian saying, well, this just fell within like a little gap. And the court says, I don't have enough for that. All I have is what the plaintiff says here. So lending further plausibility that Experian failed to follow reasonable procedures is none of the other credit bureaus reported the inaccuracy. So that is something key to keep in mind. I see a lot of judges have accepted this, and it makes sense that if you've got Equifax and let's say Trans Union reporting correctly and Experian reporting incorrectly, kind of makes you go, well, why do those other guys get it right and you can't get it right, Experian? So it's a pretty persuasive argument. So these other bureaus did not make the same error. It leads to a reasonable inference that defendants failed to follow reasonable procedures. So there are other cases that Experian cites address whether there was a fact in inaccuracy. And remember, Experian does not dispute the the fact that this was inaccurate, at least for this motion. And here's something: accurately reflects status of the account prior to bankruptcy, reflect the fact that no payment was due after. So here's what this is saying. Here's the way credit reporting is supposed to report. So let's say I have a Capital One account. I discharge it in bankruptcy on January of 2020. Well, let's say November 2020. Well, we'll back it up. Say June of 2019, it was a charge-off. Well, they could report June of 2019. It was a charge-off. I mean, that's just factually correct. That's what it was before the bankruptcy. But once I file the bankruptcy, then there should not be any negative reporting from that point forward. Now, in the past is fine, as long as it's accurate and complete. But once I file that bankruptcy, they don't need to be reporting that I'm late that month or I'm past due this amount. All that should really just be wiped out. Okay. So again, the past can stay, but once I file bankruptcy and I get that discharge, it should show a zero balance and say discharge or included in bankruptcy or words to that effect. So going back to the text here, in short, the court concludes plausibly alleged Experian did not follow reasonable procedures, and so the motion is denied. So hope you found that helpful. This was from 2 years ago, and just let me know if you like me doing these, and we'll continue to do these. Hope you are learning from them, find them at least somewhat interesting, and hope you guys have a fantastic evening or day, depending on when you're watching this, and I will talk to you soon. Okay, bye-bye.